The courtroom isn't always the quietest and most civilized place, and lawyers aren't always the most popular of people. Ever wondered what crazy things could happen to them in a courtroom? And we don't mean stuttering or losing a case. In this video, we are going to discuss top 4 biggest courtroom mistakes. The video is going to be amazing, so make sure you stick to the end. Before starting the video, be sure to smash the like button and subscribe to never miss out on any of our videos. Number 4. This Las Vegas lawyer reportedly showed up drunk to court. Defense attorney Joseph Caramagno admitted to showing up drunk to defend a client facing a possible life sentence for kidnapping. The Las Vegas Review-Journal reported back in November 2006. He began slurring his words when the judge asked if he was okay. Caramagno excused himself by telling the judge he was suffering from a concussion after being rear-ended, contending his head had been subjected to many severe contacts. Number 3. Cursing in a courtroom could get you in trouble. Attorney Therese Cesar Garza broke out the *T in front of a judge, according to this ethics complaint from the Attorney Registration and Disciplinary Commission of the Supreme Court of Illinois, which above the law posted. Judge: What did you say, Ms. Cesar? Lawyer: Oh shoot, I said oh shoot. Judge: I don't think that's what you said. Lawyer: Whatever. I know the word you think I said. My mother never let me say that, and I'll tell you why. But I said shoot, darn it. As if that wasn't enough, she then began yelling at the judge, according to the complaint. The argument is for the lawyers to do when there is a point of evidence or when closing submissions are being made. If you are representing yourself, that is when you make your arguments. Arguing with the lawyer who is questioning you does nothing to assist your case and, in fact, may only assist the case of your former spouse. Number 2. Telling your side of the story to the police. Speaking of Miranda warnings, these only must be issued if a person is in custody and law officers want to question them about a crime. That's usually done at a police station following an arrest. So even before a Miranda warning is issued, you shouldn't talk. In fact, even after it's issued, you still shouldn't talk. If you do talk, all you're doing is answering questions that law officers pose to trap you and make you look guilty. So don't talk to police when you're arrested. Don't give detectives written or oral statements after your arrest. Don't talk to other inmates about your alleged crime if you are placed in jail. And don't talk about your case in jail phones, which may be recorded. One of those rights is your Fifth Amendment constitutional right to remain silent and avoid self-incrimination or making yourself look guilty. And don't worry, by pleading the Fifth and not talking, you're not admitting guilt. You're only applying your legal right. Number 1. Failing to communicate. Though all expert witnesses have a deep knowledge of their chosen subject, the ability to communicate technical insights to the laypeople of the jury is not universal. Whereas one expert can have a gift for distilling complicated ideas into simple concepts, many others lack communication skills. According to Dodge, at trial, the primary goal is to make certain the expert is a juror educator rather than an expert witness. Too often, experts speak to the attorneys rather than the jurors. A common complaint in post-trial interviews with jurors is that the experts use language that was too technical or employed jargon unfamiliar to most people. An expert who is a poor listener, answers questions they want to answer rather than those asked, who uses technical jargon and seems unaware that their testimony will be heard by jurors and not by colleagues, Dodge adds. Improving the communication skills of an expert is one of the main areas of focus for many trial consultants. They utilize mock trials, practice depositions, and realistic reenactments to develop an expert's ability to communicate with the jury effectively. Many trial consultants will also assist in the development of visual aids and graphics designed to clarify the expert's analysis to the jury. Let us know your opinion in the comment section below. This was all for today. Hope you liked the video. Do not forget to subscribe to our YouTube channel. Stay safe, and we will be back soon with another video.